Hello, everybody. Good afternoon or morning or evening for some of you. My name is Samir Varma. I'm a partner in Thompson Hine's international trade practice based here in Washington, D.C. I would like to welcome you all to today's webinar. Before we begin, just a quick few housekeeping items. Today's program is being recorded. We will send a link to all attendees within 48 hours of today's presentation. In the handout panel, you can download a copy of today's bios, a copy of the bios of today's speakers. And also, if you have any questions, feel free to type it in the question box in the control panel. If we don't get to your question, we'll be sure to follow up via email after the webinar. Again, thank you for your interest, and we'll go ahead and get started now. If you attended our last webinar on this topic, our panelists obviously need no introduction. But just in case, we are joined today by my colleague, Francesca Guerrero, a partner in Thompson Hine's International Trade Practice, also based here in Washington, D.C. Francesca will be providing the U.S. perspective of these economic sanctions issues. Next, we have Brian Mulier, a partner in and co-head of Bird & Bird's International Trade and Customs Group. Brian is based in The Hague in the Netherlands and will be focusing on the EU/UK perspective. And finally, I'd like to introduce you to Daniel Wiedmann, an associated partner in and head of POELLATH's antitrust law department. Daniel is based in Frankfurt and will be providing the German or also EU perspective on these Russia sanctions issues. Now, I wanted to sort of kick things off with a brief background of where we are today. I know we're going to focus this discussion on the global response to Russia's invasion of Ukraine. But we think it's important to set the stage and just, I guess, provide a quick background of the war itself and sort of related consequences. I mean, as we all know, sort of, we go back to 2014, Russia originally invaded and annexed the Crimea region of Ukraine, resulting in a whole host of economic sanctions. At the very least here in the US, a complete embargo on doing business in Crimea by US persons. As well as certain sectoral sanctions related to oil producing projects. They placed certain entities and individuals on sanctions lists, either prohibiting business altogether with individuals or at least sort of limiting how you can do business with certain entities and individuals. Now, fast forward to this year, in about mid-February, Russia first attempted to sort of recognize the Donetsk People's Republic, or DNR, and Luhansk People's Republic regions as independent states. Those are located in the Donbass region, sort of in the southwest area or southeast area of Ukraine, which border on Russia. Now, by February 24th, the issue quickly escalated into the current war of aggression with Russia's sort of all-out attempt to take over Ukraine. Sadly, current estimates are that roughly 4 million or more Ukrainians have left the country. Another 6 million have been displaced within the country itself. Thousands of civilians have died. I mean, the toll of this war is obviously significant. Now, we wanted to provide this background simply to say that while we're focusing on economic sanctions, it's obviously important to recognize the issue for what it is. It's a war of aggression that has serious consequences, not only for the people of Ukraine, the region as a whole, and as well as globally. Now, putting that in perspective, I want to jump right into the international response, the economic sanctions that are being placed, as well as really the practical considerations that companies are facing and factoring into their decisions when doing business, not only in Russia, but really sort of the Russia, Belarus, Ukraine region. To kick things off, I'll turn it over to Francesca, who give us the U.S. perspective. Maybe Francesca, you can talk briefly about some of the geographical or comprehensive sanctions that the U.S. is putting in place right now.
Sure, thanks, Samir. As you mentioned, sort of the first step in February was to recognize these breakaway regions, and the quick response in the United States was to subject these regions to the same geographic-based embargo, essentially, that we had in place for Crimea. So we restricted investment, import, export, provision of services to those regions. Early on, we got some questions about how to even identify whether the scope of your contract, the scope of your engagement, whether your supplier was located in this region. It wasn't well defined. But admittedly, I think that question has been superseded by events, as there have been, in some ways, much more impactful sanctions directed at Russia. But I'm curious what the EU perspective is on the geographic restrictions. Are you getting questions about that? Do you have the same scope of restriction?
Brian or Daniel, do you want to take that?
I'm happy to go ahead. I mean, I think here in the EU, it's pretty similar. Basically, what was done was to extend the existing sanctions with respect to the Crimean region, also to the Donetsk, Luhansk region, which is essentially a ban of imports from that region, ban of certain exports, and investment restrictions. Brian, do you want to add to that?
No, thanks very much, Daniel. I think that's a pretty good overview of the current situation in the EU, where, and I think that is important to mention. We always focus on Russia in terms of sanctions, but it goes, beyond that. It's also Belarus, and it's also the regions you just mentioned. I think that's something also to take into consideration.
And I think maybe we should make the point that we do not have a broad embargo on Russia. We have many impactful sanctions, but we have not, established a territorial embargo.
That's a good point, Francesca. I think there's been some confusion about that that we've had with certain companies that have contacted us regarding sort of the complete embargoes and what areas are counted. Daniel, you mentioned imports as well. Maybe we want to talk a little bit more specifically about sort of the import bans that that the US, EU, et cetera, are putting in place. Francesca, do you want to give that US perspective again?
Sure. We've got, import restrictions on oil. We've got import restrictions on a list of certain other strategic items. But I think what we're mostly seeing questions about is companies struggling to identify whether their products are on these lists of banned imports, and whether there are certain exceptions that will apply. So there are general licenses, there are time-based implementations. Some of the restrictions haven't gone into effect yet. So that's where we're seeing some real questions about the import restrictions.
Yeah, on the EU, yes.
Good.
Yeah, I think on the EU side, the most notable one to mention is an import on certain semi-finished steel products or finished steel products. That has been quite significant. First, I mean, there's an embargo on Russia, and there's also an embargo on Belarus. And then you have to see this together with the personal sanctions we're discussing, probably will be discussing later, targeted at some of the oligarchs who control some of the very major Russian steel manufacturers, for instance, Severstal and NLMK. So what's been only a partial embargo on certain further processed steel products for these company amounts to basically a total embargo, because they are subject to an asset freeze, and you're not supposed to provide funds to them. And I mean, I was just talking to a client what that means for the steel market. I mean, for certain grades of steel, I mean, the price per ton was around 600 euro before the sanctions, and it's now gone up to 1,400 sanctions. So many traders are looking now into their force majeure clauses within their contracts and need to discuss what to do.
Yeah.
One thing I'll add, although Brian, I want to make sure I don't interject over you, is what we have seen frequently companies wrestling with is there are strategic items that they want to purchase from Russia that are not on a list of prohibited goods, because again, we don't have a broad embargo, but they're having difficulties finding the ports and transportation to ship the goods. because some of the ports themselves, and you mentioned the SDN listings. We'll explain how some of the ports have been subject to embargoes. Many of the vessels that were, carrying some of these products out of Russia are unavailable or sanctioned. So yes, the wider picture comes into play. The product might be fine, but are all the other players in the transaction, are they subject to sanction in a way that's going to make the transaction difficult or need to be restructured? I just lost. Oh, there he is.
No, I just wanted to add, Francesca. It's a valid point, and I believe Daniel just spoke about the import bans, etc. But it goes, way beyond that. What we see in the EU and what I experience with clients is that they have, some sort of tendency to do not business at all with Russian companies or goods that come from Russia. And I think it's not only to do doesn't have only to do with the sanctions, but it's also a question of ethics and to what extent at this point in time, given the political situation, the geopolitical situation, you want to do business with Russia, or where Russia or Russia-related entities, parties are involved at all. And that makes it a bit difficult also in advising to clients what to do. It's not only on the sanction side of things, but it's also on the ethical side of things that we're frequently asked to advise on, with questions like, what should we do under the current circumstances?
Yeah, and that brings up a number of sort of practical considerations. I know, Daniel, you mentioned that companies are looking at their contracts and seeing whether or not they can invoke certain force majeure clauses or other things. What are some of the other ways companies are looking at to either continue to do business, or are they looking at different supply sources, or how are companies responding?
Yeah, I mean, I think it really depends. I mean, one thing that Brian mentioned, that's an important point, is that's EU companies that want to terminate their contracts with Russian counterparts. I mean, if there are sanctions in place, they have, at least from an EU perspective, good arguments. Yeah, of course. I mean, if the Russian counterparts are not affected by sanction, that makes it more difficult, and then you really need to carefully look into the contracts, what possibilities are available. And I mean, some companies have assets in Russia, then you also need to consider the Russian counter sanctions. Yeah, so if you stop operating in Russia, what does that mean for your assets there? I mean, the Russian counter sanctions, they involve insolvency proceedings, they involve even criminal sanctions, or assets can be seized. Yeah, these has all to be factored in. I mean, if you don't have any assets in Russia, I mean, then this is maybe not so much of a concern, and it really you need to look at it on a case-by-case basis and consider the individual circumstances, as you always need to do as a lawyer.
Francesca, do you want to talk a little bit about the bill in Congress right now regarding normal trade relations with Russia?
Yes, and I'm curious. I don't know if the EU is looking at that, but there is a bill that has passed the House. It's in the Senate right now. I believe the latest news is that Senator Paul had some questions about it, and so it's no longer as fast-tracked as it was. But the bill would suspend normal trade relations with Russia, which means we would no longer grant them what used to be called most favored nation status. We will no longer grant them the tariffs that we grant to almost everyone, which are very low. And they would go, if you're familiar with the HTS-US, they would go into column 2. And column 2 tariffs are currently only applied to a few embargoed countries where people aren't really importing products from anyway. But you might see a leap in import duties from like 0 to 25, 30%. It's going to depend item by item. So for companies that are continuing to import products from Russia, and as much as companies might feel like they have an ethical consideration, there are some things like fertilizer where there's like maybe not a big global alternative. There you know, it's worth looking at how this will impact your duty rates if it passes, which I think it's likely to pass. And, you know, figuring out how, you know, how you deal with that change, you know, contractually with your customers, with your suppliers. So yeah, so that bill is percolating. It would not restrict imports from happening, but it would impose, you know, significant duties. Is it happening in the EU, or is that under consideration?
Well, I've heard, I was in Brussels just the other week, and I've heard that there were discussions pending, same as in the US, to remove Russia from the most favored nation list. I'm not sure, but then you'll just chip in if you want to. I'm not sure whether that has happened over the last days. I don't think so. But it's certainly it's discussions that are pending in the EU. But that being said, you know, I ask myself, and that may depend per member state in the European Union, but I do not have the idea that generally speaking, there's lots of trade, saying imports into the EU from Russia, except for obviously steel, what Daniel already mentioned. But I do not have the idea that, you know, in volumes, the trade with Russia is that much. So definitely it would have its impact if Russia would be removed from the MFN list. But then again, I'm not sure whether companies would be too concerned about that. But
Yeah.
Daniel, maybe.
I
Yeah.
fully agree. I think it's an option on the table, but there are no concrete steps yet. And I also agree on your second point. I mean, what are we talking about trade flow wise when talking about imports from Russia? I mean, this is of course oil and gas, yeah, and this is highly controversial. And then we have steel, and we have another major industry is fertilizers. And I mean, Belarus they have Belarus Kali, which is one of the largest potash producer. They are subject to an embargo. And we have Ural Kali in Russia. They are owned by an oligarch who's a designated person, but he seems to have divested a part of its ownership in Uralchem. And I mean, I would be very careful when starting dealing with them, whether it's really certain, or I don't think it's been confirmed yet by any public authority in the EU that he no longer controls it. Yeah, but what I said, I mean, besides oil and gas, I think most major Russian industries have already been affected either by the steel embargo or by the personal sanctions imposed on oligarchs.
No, it's a very good point. Francesca, did you want to jump in?
I was just going to comment. We have a couple questions in the question box. One of them seems on point, although to be honest, I think that the answer is I'm not aware of something that you need to put in. But one of the questions was, do we need additional information on shipments coming in from Russia, not related to oil or gas or involving an SDN? Like when you make the entry declaration, there's something new to add? I'm not aware of that. I mean, obviously, country of origin, country of export are already declared. Yeah.
I'm not aware, at least in the EU, of that there you know, any specific information has to be added to the import declaration. For sure, obviously, if there's something that indicates to the direction of Russia, there will be additional controls by the Customs Administration. Same goes, by the way, the other way around. Exports to Russia, to the extent still authorized, you know, with respect to the sanctions, there's a 100% control by the Customs Administration. But I'm not aware that you need to indicate any additional information in the entries.
I'm not aware of anything generally, although I have advised some clients who are using general licenses, for example, for import of agricultural products that might involve an SDN, to put that in their documentation so that inevitably these things will expect pickups, and you have to like move through and explain it to everyone. But put it in your own documentation.
But that's quite common in the EU. If there's any license required for the import, you have to indicate that in, from the top of my mind, it's box 44 of the single administrative document, where you have to indicate that there's the items to be imported are subject to licensing and that you hold a license.
Mhm.
Well, I think let's go to sort of the next. I mean, we've talked a little bit about imports. Maybe we talk about exports now, and some of the export restrictions that are in place. Again, Francesca, you want to start with the U.S. side?
Sure. The interesting thing for people who do this all the time now is that we have both export controls and we have this like luxury good export ban. So we've got two hats we need to use. With export controls, the scope of what's restricted on the commerce control list has been greatly expanded. Now it's everything category 3 through 9, if you all know what that is who are listening. And that's a lot of stuff, like kind of basic telecommunications devices, basic semiconductor chips, software with relatively basic encryption, that is now subject to an export licensing requirement for Russia. I'm not going to get into like the encryption issue. There are some little carve outs there, but it's a wide swath. And so that means that not only do you need to think about this when you are exporting or re-exporting from a foreign location these goods, but you also need to think about it for deemed exports if there are Russian nationals who are working at your company and having access to, control technology. They expanded or listed a new foreign direct product rule for Belarus and Russia, so that basically anything that's the product of technology in these categories but produced overseas is now subject to U.S. export controls. So it used to be you develop a technology in the U.S., you go make your telecommunications device in a different country, and that device itself was not subject to export controls, so it went to Russia, but now it is. So it's quite complicated for our companies. And then you've got this luxury goods list, which includes, things from various like food items, luxury food items, gold, jewels, to like vehicles and automobiles. So it's you have to scrutinize that as well.
Yeah, if you would compare that to, Samir, if you would compare that to the situation in the EU, I think to start with, and maybe it's a bit off topic, but nonetheless, we were speaking about export controls. In the EU, we do not know the concept of deemed exports, so that makes life a bit easier. Nonetheless, and I think that is a difference compared to the Russian sanctions and the dual-use items that are included in the US sanctions against Russia. In the EU, the entire list of dual-use items are included in the sanctions. So it is from category 0 until category 9. So it's all items that are included. And then obviously we have also the issue of luxury goods, where it's a bit difficult because there's different thresholds. There's a threshold of 300 euros, threshold of 750 euros, 1,000 euros, and vehicles 50,000 euros. So there's different thresholds depending on the type of good. But there again, it's long list of different items, varying, same as you just mentioned, Francesca, from food to gold and pearls,
electronic devices,
etc.
cigars, and
it's
so on.
Yeah.
Is there a threshold in the US?
No.
No.
I think that our categories might be slightly narrower, but I haven't done the analysis. As you know, it's quite a complicated list, but we don't have a monetary threshold.
But how are the luxury items defined in the US?
By reference to the Schedule B code and description.
Okay.
Yeah.
Like in the EU, based on harmonized system code. Yeah.
Yeah, and the threshold is, yeah, there's the statistical value of the goods. And I think what's interesting is for car parts, it's not the value of the car part, of course, but the value of the car. Yeah. So if the car is above 50,000, any car part for that car would fall under that list. Yeah. And I think maybe to add, I mean, besides that, we also have some sector-specific export controls here for the energy industry, for certain, for example, equipment, for the aviation industry, and what did I forget? The maritime sector, of course, also. Yeah.
So practically speaking, with these restrictions in place, is there in the EU, the licensing system, is this just basically a policy of denial? Meaning, there's no way to even get a license to export these types of goods into Russia?
Yes, Daniel, go.
I mean, my experience is that it's almost impossible. You have to have super good reasons, yeah, so that it's critical for supplies in the EU, or that you send that part abroad, or that it's life-saving for life-saving exercises. But generally in Germany you don't get a license. Yeah.
I think indeed, Samir, and I think this is just an indication of how the different EU authorities look at this issue. We have seen in multiple member states that export licenses were withdrawn that included exports to Russia, were all withdrawn at the moment the sanctions kicked in. And up and until now, we have not seen that any of those licenses have been re-granted. So I think that's the good indication. Like Daniel said, you should have very good reasons to export items to Russia, and got a license for that.
Yes, and I will add, I have some clients who have products held up at at ports in the EU, of products that would theoretically be in transit and not really entered into commerce, but are being held at ports because the customs authorities are being very conservative in Europe about even authorizing,
No, I think that's generally the take. And again, the EU is like 27 different member states, 27 different attitudes, different approaches. But I think there's one common approach with respect to the sanctions against Russia, and that is that all these authorities are very careful, which means indeed goods that are in transit are being stopped. All containers or all goods destined eventually for Russia are 100% controlled and audited by the customs administrations. And it's rare that goods are released and shipped to Russia. And then again, especially where a license is required, I don't have seen any instances where those licenses have been issued.
We have another question that maybe I'll throw to you, Samir. You can answer this one first. It's a screening question, which I know we will get to in another section. But if let's say you have a customer in Russia who has a way to make payment, because we'll talk about how the financial sanctions make it hard, but they have a affiliated company outside of Russia that will make payment, and you have a product, you think it's not a dual use product, so it's not restricted. What sort of process would you be thinking about from both the US and EU perspective? What sort of screening do you need to do for the end users, the parties involved, a transaction like that?
Yeah, and this is a good segue into sort of the financial sanctions section, but really, we talk about screening, but it's from the US perspective, and maybe we can even talk about this from the EU and UK perspective. From the US perspective, screening is not the only thing, right? Not only that, because of OFAC regulations concerning the 50% owner control rule, you really have to go deeper into the different companies and their ownership to make sure that none of the entities or any of the oligarchs or any of the denied parties or anything like that. And furthermore, when you have banks involved related to the payments from the banks and making sure those banks are SDNs, but even if they're not SDNs, if they're on other lists, if it's for example, whether or not there's no creation of debt or equity that's greater than 14 days. And so you're looking not only at just sort of the screening process, but you're looking at all the contracts involved, whether or not you want to put in place certifications that basically state that the products aren't being used for any sort of purpose that is prohibited by the regulations, whether the parties are not owner controlled by any SDNs, et cetera. I mean, I think it's the same and sort of the same ideas in the EU and elsewhere. Right?
Absolutely. Just one thing to add to that, and then of course, I mean, you talked about contractual guarantees, which I think are very important. And just to add to that, of course, then the contract should not be subject to Russian law or to Russian jurisdiction of Russian courts, because then this won't help you, because they would disregard these reasons, of course. Yeah? So that's also something to consider. That you apply either foreign law or yeah, maybe arbitration or something like that. So.
That's a good point. Brian, anything from your perspective that you would add?
No, I think, and I think it's good to bear in mind that it's not only the screening itself, and but more in practice, how far do you go and what information do you get when you screen parties? In practice, it seems difficult to screen parties until UBO level. Notably bearing in mind that all this information is not available in public registers in Russia, unlike, for example, in the EU and in the US, where you can get this information, who owns the company, etc. So it's very difficult to get that information, and it's really up to the companies to decide what level of comfort they're looking for before they decide to proceed with a transaction. And then indeed, the contractual arrangements, which Daniel spoke of, are very important.
I think that's right. I mean, all of this is, everything we're talking about here is risk mitigation, right? The idea of to lower the amount of as much risk as possible when you're doing these transactions. And I know in other areas of U.S. law, for example, anti-bribery or the FCPA, the DOJ has sort of made it clear that certifications are not enough, right? That you have to do more than just sort of the basic certification or the basic contractual clause. You have to do a little bit more, go deeper. I would apply that to this situation as well. Going into sort of financial sanctions and the whole host of financial sanctions that are present right now all throughout the world. I mean, Francesca, do you want to dive into a little bit of the U.S. side?
Financial sanctions?
Yeah.
Right. So that is incredibly complicated. So for people, companies trying to wrestle with this, we sympathize. When we say that for every transaction, you want to look at the product, you want to look at the end use, you want to look at the end users, you want to look at the parties involved, the finance piece I find often to be the most complicated. So what the US has done is they have added a number of banks in Russia to the SDN list. That means transactions are prohibited for US persons, period. But you have to, again, scrutinize the financial companies involved to see if they might be owned by a sanctioned bank. They're not all listed. You have to look at the ownership. But then they've also created a number of directives building off of the pre-existing ones from after Crimea that prohibited dealings in debt or equity. And mostly the new ones are Sberbank right now, which is extremely, has lots of operations everywhere. And so the debt and equity restrictions may not, keep you from processing a simple wire transfer, but it might impact insurance guarantees. It might impact credit facilities and all of these different different actions. So the financial sanctions really mean that whenever you're thinking about a transaction involving Russia, you need to think about, okay, where are the payments going to go to? Is there any sort of, aside from those two immediate banks, is there some sort of credit facility like the Exim Bank of Russia that's closely involved, which is also sanctioned? There's restrictions on the Central Bank of Russia, Ministry of Finance from the US, that don't block transactions, but they prohibit most transactions. There's a bunch of authorizations that create exceptions to this rule. So it's quite complicated. But we are, weeding through it and we're figuring it out.
And I think that there's a question here from one of the attendees that is sort of on point here. It is a difficult question to respond to, and it's basically, how can Russian companies pay their U.S. suppliers when now that the central bank's assets are all, a central bank's foreign currency reserves have all been frozen. And then the question goes on to ask sort of how to convert rubles into U.S. dollars now that Russia's implementing capital controls. And I'd love to hear everyone's perspective on this, but this really is a difficult question, and the reality is that not only is it difficult to sort of consider the economic, sort of financial sanctions that are in place, but the reality that the banks, U.S. banks, other European banks, et cetera, are all acting so conservatively in this area that any business with the central bank and their foreign currency reserves or converting rubles into U.S. dollars or anything like that is going to be scrutinized heavily, almost to the point where it won't happen, right? I don't know if you want to, with Francesca or Daniel or Brian, you want to jump in there and sort of talk about how.
Well, what I would like to add, what I would like to add, Samir, is first of all, I fully agree with Francesca that of all these sanctions, the financial sanctions are maybe the most complicated and the most difficult to deal with. What we see in practice and where we get lots of questions from clients is once you have analyzed all the different sanctions and you came to the conclusion that it's okay, it's legitimate to do business with a Russian party. You also take into consideration the ethical part of things. Nonetheless, whether it's new business or maybe obligations following from an existing contract, you do business with these Russian parties, then the very next question is, but how can I ensure that I will get paid for the services that I provide or the goods that I've provided to my customer? And that's, I think, the most difficult part. It's the whole process of payment. It's invoicing, it's payment, it's the banks that are involved. What is the reaction of the European banks, the EU banks, if monies are being wired from a Russian bank that is not an SDN to an EU account? What we see is that the EU banks generally take a very conservative approach and do not touch those amounts. Get lots of questions as a customer. What exactly this amount relates to? What it is paid for, etc., etc. So it's really difficult, even if you get to the conclusion that it's legitimate to do business with a Russian party. To get your remuneration in eventually takes even more time than that.
Daniel, do you have any thoughts on that? Or?
No, I think basically I don't have to add to that. I mean, I think that summarizes it as well. I mean, there are, of course, further financial sanctions. I think there's a huge package in the EU, but from a practical perspective, I would say these are less relevant, so we may not need to go into detail here.
Yeah. Okay. Well, let's move on to sort of what we're referring to as the personal sanctions, and individuals and entities that are being sanctioned. We can start with the U.S. perspective again if you want.
I think we've touched on this already, but it's important to emphasize that, you know, there are broad sanctions that we look at first. You know, is the product, you know, permissible? But then you need to look at the parties involved, because there are a number of sanctions that target particular companies, oligarchs, and then all of the entities that they own from a U.S. perspective, also control from a EU perspective. And so the kind of parties that you need to look at and screen include your counterparties, as well as sort of maybe the port that something might be shipped out of, the vessel it might be on, distributors and sort of middlemen who are acting in the transaction. And you know, there's actually a lot of complicated questions there regarding, you know, how the EU and the US treat these, like if you're talking about a business entity, maybe I'll let Daniel or Brian jump on the aggregation question, and then we can contrast it to what they do in the US. But you know, every entity isn't owned by one person. So what do you do when you've got like 3 SDNs, one sectorally sanctioned entity, and you know, 5 people who are, as far as you can tell, not subject to sanctions?
Yes, I mean, actually, Brian and I just discussed that before the call. And Brian, maybe you want to start with the UK approach.
Yeah, well, yeah, there was an interesting guidance from the UK authority, OFSI, let's say the counterpart of OFAC in the UK, was issued the other week, saying, well, you know, we do not simply aggregate if a company is being owned by 2 persons and none of them 2 or more persons and none of them having more than 50% of the shares, then designated. We do not simply aggregate the persons and their shares. Unless there is a joint agreement between those parties, or there is an agreement on voting rights where the one holds the voting rights of the other. So that's a clear guidance that is issued by the UK. We do not simply aggregate, full stop. And then there was this interesting guidance from the EU, right, Daniel?
Yeah, let me maybe first start. I think that the guidance from the German government is exactly the same as the one from the UK. The German government says you don't aggregate, for instance, shares held by designated person A with the shares held by designated person B, unless there are concrete indications that they exercise their shareholding together. Yeah. And now, I mean, the European Commission has issued basically a statement to the contrary, or appears to have issued, because we just discussed that with the German government official and said, okay, there's need to discuss. But what shows up on the webpage on the European Commission is the contrary. I mean, they give the example: you have designated person A holding 25% of the voting rights and designated person B holding 26% of the voting rights, and then you would say, okay, then you would need to aggregate that, and that subsidiary could be subject to the same sanctions as well, yeah, asset freeze and prohibition to provide funds to it.
Whereas the US, I think, has the same position that the European Commission may have put on their website. They do aggregate, but only like kind. So with Russia, you might have sectorally sanctioned entities subject to debt restrictions or certain directives, but not SDNs, and that would not be aggregated together, the SDN and the sectoral sanction. Yeah, it sounds complicated, but you know, what is also interesting when you have that question is we have had clients who, for example, are dealing with a subsidiary of a Russian oligarch or 2 in the US, and they have the sense that the UK or the EU treats it as a sanctioned entity because they think it might be controlled by that oligarch, even if it's not 50% owned by the oligarch. But in the US, they don't treat it that way. So we have to look at jurisdiction. Does the EU interpretation matter to this transaction? And sometimes it doesn't. So you go with one interpretation. You don't have to look at all of them. But yeah, it's
No, it's a good point, Francesca, because indeed, Daniel and I were just speaking about ownership, but there is also the concept of control. If you look at the EU sanctions, but also the UK's, by the way, it says owned or controlled. And, the aggregation relates to ownership, but there's always what remains is control. That makes it indeed very difficult because you also have to dive into the control and need to establish whether a company is controlled by designated person or plural designated persons, which is even more difficult to establish than the ownership sometimes is, because there's a long list of indicators which may lead to control, but it's very difficult to tick the box and go through all these indicators and establish whether a person controls a company. So that remains a difficult part when applying EU UK sanctions. Is a person or an entity designated if the ownership is not as clear as it is?
Yes, there's sort of a list of examples by the European Council what can be seen as control. I mean, 50% plus ownership is the clearest indication of control. It's rebuttable though. And for example, if you have the right to nominate more than 50% of the members of the managing board, for instance. What is interesting here, though, is that we have a lot of companies that are or have been publicly by authorities been regarded as controls because they are or have been majority owned by oligarchs, and what we see a lot is that they are changing their structures. That oligarch A divests a certain part of his shareholding just to fall below the 50% threshold, which is the most clearest one. And I would underline what Brian says, that in these situations you need to be very careful that this is really now really whether that gives you enough ground to consider that the company is no longer controlled. Yeah, because I've been aware of cases where there have been contractual arrangement in place that still afford control to the designated person, even though in a no longer transparent manner. Yeah. What I would like to add is also, because we see that in practice there is, talking about personal sanctions, as we all know, they're basically twofold, that it's the asset freeze and the prohibition to provide funds. As regards the asset freeze, there is under EU law a sort of possible derogation on a case-by-case basis, using a risk-based approach if it can be sure that the funds to be provided will not be provided for the benefit of the designated persons. Yeah, and actually, I see that applied in practice in certain scenarios, but usually what you do is you would not do that on your own because it's too risky, but only in coordination with the competent authority. Yeah. So for example, if these certain goods are frozen in the EU and there's a certain need for them, yeah, for very good reasons, then there is a possibility to discuss with the authorities whether they would lift the freeze, basically.
And in the EU, do they allow you to debit accounts to make payment to someone else, like debit an account of a sanctioned individual to pay a third party?
If the account is frozen, yeah.
That is different than the United States.
So maybe we can quickly talk about penalties, sort of liability considerations in each of the jurisdictions. Maybe we want to start with the EU or UK, or first. Brian, you want to start?
Shall I start with the UK, and then Daniel can chip in on the EU? In the UK, what has changed is that for the sanctions against Russia, there's a strict liability, meaning that where Daniel can maybe expand on that. Before the EU sanctions, the sanctions against Russia came into force, penalties were issued unless you as a person had no reasonable cause to suspect that you would infringe the sanctions. That has been removed now. There's a strict liability. So the concept of, not knowing or no reasonable cause to suspect has disappeared. Every infringement, every breach of the UK sanctions against Russia can be penalized. That is slightly different in the EU, isn't it, Daniel?
Yes, maybe. I mean, for the EU, I mean, you have a certain standard under the regulation, but in the end, the law of each member state is decisive. Yeah, and I mean, I think the EU approach, and that's where what you're aiming at, is that I don't know the English word, unfortunately, because I only have the German version language. For me, it's that, how you say, it has been reasonable. You have to undertake reasonable efforts, or is that what you're aiming at?
Yeah, well, it's the reasonable cause to suspect.
Yeah, exactly. Yeah, and I mean, talking about penalties, yeah, I mean, for example, speaking about Germany, I mean, there are criminal sanctions for intentional misconduct, and monetary sanctions, significant monetary sanction for negligence.
And I think that's in the EU. That is, again, it's 27 member states with 27 different jurisdictions in that respect when it comes down to criminal law. So each and every member state has its own penalty system and its own methodology. It could be in some member states, I think the majority of them, it's imprisonment, the maximum penalty, and financial penalties. But the financial penalties can, well, hugely differ per member state. There are member states where the financial penalties, and I think Germany is one of them, can really add up, where there's other ones where the administrative penalties or the financial penalties are relatively low, let's say.
Yes, that's right.
Yeah, I mean, from the US perspective, civil liability is pretty strong. I mean, per transaction for both sanctions and export violations, it's over 300,000, per instance, and you can have multiple instances of a violation, repeated transactions. There's also penalties in certain circumstances up to twice the value of the transaction. And criminal penalties can include imprisonment as well for individuals. Getting to your question about when do you have liability, that's kind of complicated under the US. I think technically from a legal perspective, it would be strict liability. But the same concept that you talk about, like the reasonable cause to suspect, does exist when we're talking about things like diligence. I mean, there is an expectation on the part of the regulators that you will take reasonable care, you'll do diligence, and if you take those steps, it's less likely that you will be penalized in the enforcement guidance. So it's a bit, I think, a bit of a hybrid in terms of the liability standard.
Yeah, I would agree. I mean, I think from the US perspective, it all comes down to sort of the definition of knowledge, and when you have reason to know that there was a violation or suspected violation, or whether or not there were sufficient diligence put in place to sort of mitigate that chance of you understanding or knowing that there was a violation, right? I mean, there's all sorts of knowledge theories here in the U.S. regarding willful blindness, reason to know, et cetera, et cetera. So it's a little bit, it's not necessarily sort of a strict liability sense, although it in practice it basically is. We have a few minutes just to, I thought maybe we could go down the line and just talk a little bit about compliance, practical considerations relating compliance with all of these. We talked about so many different areas: exports, imports, financial sanctions, personal sanctions, etc. Maybe we can talk a little bit just about how companies are, what procedures, what policies, what things companies are doing to sort of remain compliant or try to remain compliant in this space. I don't know if Daniel, do you want to go first this time?
Yes, that's a good question. I mean, first, I mean, in the German law, it's usual that most companies have a sort of compliance officer, and that's the same for trade compliance. But that's only where it starts. I think what's important is that you really in particular, if you have relations to Russia or Belarus, business relation, that you look at each angle, yeah, and this does not only be is not only your exports and your purchase side, but also your logistics and everything. That all that comes together. That you have, that everyone knows, yeah, what to look at. Yeah, I think that's the starting point. And then I mean, when the sanctions came into place, or there were first rumors that sanctions would come into place, I think the first thing is that you really look at your contracts, yeah, and also at your pending contracts negotiations, because sometimes even the conclusion of a contract may infringe the sanctions, and that you put that on hold or just negotiate contracts subject to a condition precedent, for instance. All these things, yeah, but there are so many more, and I'm sure Brian will add to that.
Yeah, well, I mean, going back to purely to compliance and what to do is, in my experiences and speaking to many companies, many clients, is that everyone is very careful. As soon as the word Russia is there, then everyone is, really careful and cautious at that point in time. And what I see is that in the companies, the compliance officers, legal counsel, whomever is involved in compliance is looking carefully at all transactions, screening all transactions, and moreover, and that's I think an important point, keep records of those of the screening results and everything that has been done to finally reach the conclusion that it's okay to proceed with a certain transaction, and especially the screening results. And I always say, if there's a hit, like one of those persons is an SDN, then obviously you stop the transaction. But keep records of all the screening results you have. But even, and maybe even more important, if there's no hit and you believe it's legitimate to proceed with a transaction, make sure that everything you has done is in your files, is in your records. And that's, I think, an important point in compliance, that all those records are up to date, that you do your utmost best to ensure that you are compliant with the law. And I think that's the main message.
I think I agree with all of these comments, and I'll just add a couple things. Stepping back from the transactions, the big picture, a couple tips we have is to look at your third-party banks. We've had some clients, especially those still operating in Russia, send us lists of all the banks that they have pay-to instructions, so they can screen those and try to identify problems before they try to make a payment, and it turns out it's a subsidiary of some sanctioned bank and the money's frozen. Like, we're not worried it's going to get through, we think the banks will stop it, but then you have a frozen payment and the bank's reporting the fact that you attempted to make this payment. So screening your third-party pay-to instructions is one. Taking a look at your customers who might be taking your products and resending them to Russia, especially if you have operations in Asia, and if you have operations in China, in Europe, except I think they're very conservative. In China, I think that they're being conservative as well because of the financial considerations, but I think they might still have, you might have customers who send stuff to Russia. Is that okay? Analyzing that piece of it. We know a lot of the chip manufacturers are notifying people in China and other places that their chips cannot be sent to Russia. So you're getting like the supply chain notifications. Another sort of piece that I mentioned, which my EU colleagues don't have to worry about, is the deemed export piece. Take a look at your HR. Do you have individuals who might have export related restrictions? And deemed export, for those of you who don't know, is when you have someone who's a non US citizen, non-permanent resident, usually, who is like working on a visa, and they have access to technology while they're in the US. It's considered a deemed export to that person's country of citizenship. So, you know, think about that from an HR perspective. And yeah, Samir, any last tips? I think we're right at the top of the hour. Good job, guys. Samir,
No, I mean, I think I agree with all those points. I mean, we look at end users, end use, end destination, all the middlemen, everyone in between. You know, it's you have to look at the whole holistic package here. Well, thank you. I know we've hit our time, so thank you, Francesca, Daniel, Brian. Thanks for joining. Thank you to all the attendees. I'm going to do a quick plug for our blog, thompsonhinesmarttrade.com. If you're if you're not currently receiving updates or invitations, I encourage you all to go on to thompsonhinesmarttrade.com, log in, and start receiving our mailings. Thanks so much again for all your interest, to everyone, to all the attendees. Enjoy the rest of your day. Thanks.
Thank you.
Bye.
Thank you. Bye.
Bye.